Samantha Shepherd, and I'm an elder law and special needs attorney. And here with me is Kristen. She is Kristen Armstrong from Hutchinson, Kansas, and she is also an elder law and special needs attorney. The first topic that we are going to address with you is whether or not a guardianship and conservatorship is appropriate, or whether you can survive and navigate life appropriately with your loved one with special needs without the use of a guardianship and instead use the power of attorney. So what do you think you generally see, Kristen, when people come into your office and they automatically assume they need a guardianship? What's a typical scenario you see?
So one of the things that I hear is that my child is 17 years old and he is about to turn 18, and I've been told that when he turns 18, we need to automatically get a guardianship. Otherwise, the doctors won't talk to me or I can't receive information. Usually it's medical related, and not necessarily so much about the financial decisions at that point. But at that point, it's more of a looking at the situation and looking at what his ability is. Because I always want to look at the least restrictive alternative, which may mean that we could put a power of attorney in place. So.
That's exactly what I see, that the families have often been told from a very, since their child first entered the school system, that a guardianship is in your path, that when you have a child approaching the 18th birthday, you need to be right on that or you're going to miss your window of time. And just as you said, Kristen, my first response is always, let's take a time out, take a step back and see if we can survive without the guardianship. So in Kansas, guardianship and conservatorship sort of go hand in glove. Guardianship is those decisions about the person, every decision except for healthcare. So did I just do that backwards? I did. There you go, a learning experience for us all. So the guardianship is everything except for the money. Conservatorship is money, guardianship is everything else, and they usually go right together. See, I couldn't even separate it in my mind. So there are certain instances when we work with a family to do one or the other, but the majority of time we just go for both. So I think Kristen and I can both give you an example, and Kristen will go first, of a family that does not need a guardianship that comes into us with a child with special needs. You first, Kristen.
Okay, maybe I've got a client that is fully able to make his own decisions and pretty much understands when a doctor is talking to him about this treatment or that kind of treatment. He's able to make those kinds of decisions, and so we don't necessarily need a guardian over him. But he's not great at making financial decisions, and so do we need what we call a voluntary conservatorship, or can we use a power of attorney? And I think in both of those situations, I would jump right towards or stay with the power of attorney on that situation. But if he's able to understand the decisions that he's making, I mean, that's really the threshold for capacity there. So
a scenario I had only this week sticks right in my mind, and it is a wonderfully warm family, husband and wife, loving family unit with a child that has a disability. And exactly as Kristen and I described a few moments ago, I heard that their school principal had suggested that a conservatorship and guardianship was appropriate. And I started asking a lot of questions, and my questions were, at what age did the disability begin? What level of functioning does your child have? Can he or she make change, understand dollars, find an apartment for himself, navigate the school system? So that the family started getting a little bit, we want to encourage him. We'll just say it was a young man. We want to encourage him. We don't want to put limits on him. He does intend to drive. And I said, oh, okay. How about politics? Is he interested in voting? And they said, perhaps yes. And so here I'm now thinking, okay, I'm backing away from the guardianship and conservatorship. And then I said, well, IQ is a tough thing, but do you have any, is there an IEP in the school, and do you have any cognitive testing? And they said, well, we do have an IEP. We're not sure what it says it's, but he functions at a third grade level. And then I went, oh, okay. So third graders, typically, I have a bunch of children, third graders are not generally able to find living arrangements by themselves, and they generally wouldn't be able to manage a checkbook. So I'm leaning again towards guardianship in that case. So I don't want a child's hopes and aspirations of wanting to thrive are perhaps unrealistic. So I paused and said, we can always reverse ourselves. If we go down the path of having a guardianship and conservatorship and find that your child matures to a level where it's not appropriate, we can go back. We simply go to the court and say, we would like to terminate, and here's why. And we don't do that often in reality, but we have done it. And we restore capacity is what we use in the legal vernacular. Kristen, how about if you give a bit of background on what exactly is a power of attorney and when can we do one?
Sure, sure. I'm going to touch base. You just mentioned it kind of briefly before I talk into that, but about voting. People don't realize, so what is the guardianship process? You hear about it, and yes, it's about making somebody's legal decisions, but you're stripping them of some of those rights to make decisions. And one of those rights, legal constitutional rights that may go away with a guardianship, would be that right to vote. So that's why it's such a serious thing, and why the power of attorney is considered to be the least restrictive alternative. So a power of attorney can be written very broadly, where we can take care of a lot of different things, or maybe it's written very narrowly. This one's kind of funny, Samantha, I don't think you know that I did this, but I had a client that is really into pets and really into their animals. And so we have a broad power of attorney for them, for a husband and wife, so that people can manage their affairs and do things for them if they're not able to do them for themselves for whatever reason. Either they lack mental capacity at the time, or are just physically unable to do those kinds of things, or maybe husband's not able to get off of work to buy the house, so the wife helps to sign. So there's lots of reasons people might use that. But so that's the example of a broad power of attorney, is we can do lots of things, such as making banking transactions, picking up mail, securities, investments, businesses, any of those kinds of things. Whereas the power of attorney that I did for the pets is a limited power of attorney. So we had certain people that we wanted to handle finances and things over here, but they wanted certain friends to manage the pets over here and make decisions for the pets, for treatment options and things like that. So there's an example of a very broad power of attorney, general, sometimes called a general power of attorney, or a general durable power of attorney. And then the other hand would be a very limited purpose, such as maybe
I just adore you. You think outside the box. You just crack me up. I love that idea. So let's say the 18th birthday. It's the family calls you, and the child is about to have their 18th birthday on Christmas morning. So here we are in, what are we in? September. And it's Christmas morning coming up. We've been told that we need to get this power of attorney. Oops, we didn't know about the power of attorney. We've been told we need to get the guardianship, and they never say conservatorship, by Christmas morning. So when do we go into the lawyer? How long does it take? And can we both be named?
So
I'm asking you.
I'm going to give you the lawyer answer. It depends, right? It depends.
No.
So first of all, the judge around here, and what does it depend on? Usually it's the judge, and the judge that you're in front of. There are some judges, I think the judge in Wyandotte County, one of the counties here in Kansas, does not like to appoint two people as co-guardians. They like to just have one person. So
My office thinks, there we go. I wasn't moving enough. The lights went off. I'm sorry. So it's judge dependent. It's judge dependent.
Yeah, the judge may or may not allow co-guardians, whereas around here, they can have co-guardians. And it works well, especially if we've got parents who are divorced and both parents have joint custody and both want to make those decisions when the child turns 18. The other thing to consider is, when do you come in to see? You can come and see the attorney and talk to the attorney anytime before. But the medical evaluation, I have this come up in a guardianship proceeding, the medical evaluation has to be done after they turn 18, if you want to use that. So medical evaluation is something that is required in the court proceedings so that the judge can say, can have a little bit of background on what the disability is and what the reason for a guardianship is. So.
Okay, so my rule of thumb would be don't come in the day before you need it, and it's a little too late for me to hop on my bike and run to the courthouse. But I would say you want to schedule your hearing as close, if they're assuming guardianship is the right way to go. We want to schedule the hearing as close as we can to the actual birthday, and it has to be after the birthday. So on or after the birthday, and it does very much depend on your particular judge. So that means that, I suppose, begs the question, what judge? It's the county of residence. So if you live in Johnson County, where I reside, you're going to go to the Olathe courthouse as close to the birthday as possible, and it's through the probate court. How much time does it take to get an audience in front of the probate court judge for a guardianship? It can take 4 weeks. I think they prefer if they're given 8 weeks, and they will put you on their schedule. Before that time, you're going to want your lawyer to have a minimum of 2 weeks to get the paperwork ready, preferably 4. So you're going to back away from your birthday by 12 weeks. I think that's right, 4 plus 4 plus 4. So 12 weeks before the birthday would be an ideal time to visit with the attorney and say, help me evaluate, do we do guardianship and conservatorship, or do we do power of attorney? Because that gives us enough time, if power of attorney is the right decision, to go forward. So let's come full circle and say, on the topic of powers of attorney versus guardianship, it is an individual determination that you want to make with your attorney and your both parents in an ideal world, with input, if possible, from the child, if appropriate. Now, if your child has no ability to process any, to derive any positive thing from the hearing, the judge will permit your child to skip the hearing altogether. Likewise, if your child doesn't have any meaningful contribution to give to the attorney meeting, then it can be a meeting with just mom or mom and dad. Before we close up on this topic, Kristen, what else do you want to cover? Did we miss anything?
No, well, I will say within the power of attorney, I'm going to jump back to the power of attorney, but within the power of attorney, so if we have appropriate mental capacity to sign the power of attorney in the first place, under Kansas law, the person named under a power of attorney has preference for a guardianship or conservatorship if one is later needed. So basically you're telling the judge, you know, I signed this, the person that's petitioning for the guardianship would say, they signed this power of attorney, and when they had appropriate mental capacity, this is who they wanted to be their guardian. So judge, please appoint me. So
I don't want it to sound too lawyerly, because I don't think our audience today is mostly going to be attorneys. So petition sounds like a lawyerly word. What do you mean by that?
Asking the court. Asking.
Yeah, so think of like the old courtrooms in England, or we petition the king for this, but in the lawyer world, it's a written document that the attorney writes. Dear court, we represent mom and dad. They want to be the guardian and conservator for their son, Billy. He's about to turn 18 on Christmas morning. He suffers from cognitive impairment. He has cerebral palsy, autism, Down syndrome, or whatever his particular concerns may be. And then they ask you also for all of the family members and people who would contribute. Okay, that's a wrap on power of attorney and guardianship. Thanks very much.
Thank you.